Hello, my name is Nelson Abbott. I'm an attorney in the state of Utah, and today I'm going to answer a question about business entities and what kind of business entities are allowed in the state of Utah. I'm answering this question because we frequently get asked this question by clients, and so I thought I'd put it up on the website, and maybe you'll get some benefit by listening to this video, I hope. So, before I get to the type of business entities, I first want to talk about kind of some of the factors that we're going to consider in deciding what type of business entity to form. So some of the factors to think about is how hard is it to create, what kind of liability is there for the owner, what tax considerations are there, and how hard is it going to be to raise capital. So that's what we're going to do, is talk about those issues, but before I get there, the other thing I wanted to talk about was a DBA. A lot of times people ask me, well, what kind of business entity is a DBA? And a DBA is not a type of business entity. A DBA is merely it's a piece of paper that's filed with the state of Utah. It's called a doing business as, and it gives a person or a corporation or an LLC the right to do business under a fictitious name. So for example, my name is Nelson Abbott. If I were running my law firm as a sole proprietorship, I could file a DBA and I could say I want to do business as Abbott Law Firm. Now, I wouldn't have to run it as Nelson Abbott. I could run it as Abbott Law Firm, and that might be better for marketing purposes. But it doesn't change the fact that I'm running it as a sole proprietorship. In reality, I'm not a sole proprietorship. I've set up my law firm as a professional corporation, so the true name of the law firm is Abbott and Associates PC. But for marketing purposes, I thought, well, maybe Abbott Law Firm would be better. So I filed a DBA. So it's Abbott and Associates PC, doing business as Abbott Law Firm. And that gives me the right to put Abbott Law Firm on advertising materials, and it does not change the fact that I'm operating this law firm as a professional corporation. So let's go through the types of business entities that there are in the state of Utah. There's number one, a sole proprietorship. Number two, we've got partnerships. Number three, we've got limited liability companies. Number four, we've got corporations. And number five, we've got limited partnerships. So let's start with a sole proprietorship. A sole proprietorship is just merely, it's the simplest form of business entity there is. When any person goes into business, they become a sole proprietorship. It's really easy to create because there's nothing to file with the state of Utah. All the person does is just goes into business, and then it's just automatic. So ease of creation is really easy. Second, it's very flexible. Third, it's gives the owner complete control over the business. They don't have to deal with others. They don't have to have shareholder meetings. There's no board of directors. There's none of that type of complication exists with a sole proprietorship. So those are some of the advantages. The disadvantages of a sole proprietorship, probably the single most biggest disadvantage, is that there is no limited liability. In other words, the owner of the business is completely liable for all business debts. Doesn't matter where the business debt comes from, the owner is liable for it. And when I mean the owner is liable for it, I mean the debtor, the person who's owed the money, can go and collect that debt against the personal assets of the business owner. So there's two examples I'll give you as to how that works. The first is, let's say a sole proprietor wants to go out and lease a business, lease real property to run the business from. So the sole proprietor will sign a contract with a landlord, and let's say it's a 5-year contract, and then the business doesn't do very well, and so the business stops paying the rent after, say, a year. So there's 4 years left on the lease. The landlord now at that point can file a lawsuit against not just the business, but against the business owner, and get a judgment against the business owner. And if the business owner does not pay the judgment, the landlord can go and take the business owner's house potentially, or car, or other personal assets of the business owner in order to satisfy that debt. That type of debt usually isn't a huge problem because it's measurable, controllable. When a person goes into business, they know what contracts they're entering into. and so they can kind of manage that. And it really doesn't make a huge difference because most landlords will require small businesses, the owners of small businesses, to make a personal guarantee. So that one's not a huge concern to me. The one that's a bigger concern is tort liability. Now, tort is just a legal term that most people would call personal injury. But so, for example, a sole proprietorship hires an employee. That employee is driving a vehicle somewhere and is in a wreck. And unfortunately, it's the fault of the employee. Now, because the employee is working within the scope of their employment, the business is now liable for any damage caused by that automobile accident. And unfortunately, in this hypothetical, somebody's injured, and so the business is liable for those injuries. And because it's a sole proprietorship, the owner of the business is also personally liable for all of those injuries. That's a really hard type of liability to manage, because those types of debts are hard to predict and hard to control, and they can be quite large. So that's a very dangerous thing for a small business owner to go through, and I would call that a huge disadvantage of a sole proprietorship, is not being able to control that type of liability. Another disadvantage of a sole proprietorship is it's really hard to get financing. Banks, venture capitalists do not like to give money to sole proprietors. So those are some of the advantages and disadvantages of a sole proprietorship. Let's go on to the next thing, and that is a partnership. A partnership is very similar to a sole proprietorship. The only difference is that instead of one owner, there's two owners. But as far as when we go down and we say, well, ease of creation, it's the same. It's really easy to create a partnership. Now, smart partners will enter into a partnership agreement, but it's not required by law. And if it's not done, then the partnership statute, actually goes through and lists some kind of default provisions. And so there's kind of it's not really a de facto partnership agreement, but some things that are normally covered in the partnership agreement are now determined by statute. So it's really easy to create a partnership. That's one of the huge advantages of it. It's very flexible, it's informal, and generally speaking, the partners share profits and losses equally. That's not really required. That can be modified in the partnership agreement, but that's a common thing, and if it's not defined, then the statute says that's what happens. Disadvantages of a partnership are very similar to the disadvantages of a sole proprietorship. So one of the disadvantages I talked about with a sole proprietorship is there is no limited liability, and that is true also for a partnership. Now, if you think about it, it's maybe a little worse in the situation of a partnership, because not only are you liable for your own debts, your own mistakes, your employees' debts, but now you're also liable for your partner's mistakes and their debts. So that's probably a bigger disadvantage in a partnership than a sole proprietorship, but I would call those equal. It's a big disadvantage in both of those. Another disadvantage with a partnership is if either partner dies, the business is automatically dissolved. It comes to an end. And finally, I will say a disadvantage of a partnership is it's very difficult to raise financing, similar to a sole proprietorship. So let's see, I think I've covered everything with a partnership, so let's go on now and talk about a limited liability company. A limited liability company is a lot like a partnership, but one of the big differences is it kind of bridges the gap between partnership and corporation. And so one of the big differences between a limited liability and a partnership is a limited liability company is only formed when the owners file a piece of paper with the state of Utah saying that they want to be a limited liability company. If they fail to do that, they are called a partnership, not a limited liability company. So it's very important to file that piece of paper with the state of Utah and to do it right from the very beginning. So some of the terms that we do a little different in limited liability company. For example, in a partnership, we call the owners partners. In a limited liability company, we call them members. A lot of times I'll hear people say to me, I'm a shareholder in a limited liability company. That's not really true. They're not. They're a member in a limited liability company. There are no shareholders in limited liability company. Sometimes they'll say, oh, I'm on the board of directors. Well, technically under the statute there's no board of directors. So it's more likely they're a manager or something like that. So one of the big advantages, well, let's go through the advantages and disadvantages of a limited liability company. Some of the advantages are, let's see, the huge advantage, I guess, I'll start with, is in a limited liability company, the owners are the only thing they put at risk is what they put into the business. So that's they can control, and that's a huge advantage, they can control the extent of their risk in the business. Other advantages of a limited liability company is it can, for example, for tax purposes, it can be counted as a pass-through entity for tax purposes. It's taxed like a partnership or an S corporation rather than a C corporation, which has a problem of double taxation, which we'll get to in a minute. And another advantage is that profits can be distributed unequally to the members, to the owners of the limited liability company, and losses can be distributed unequally too. And one of the really nice things about a limited liability company is that profits and losses don't have to be distributed in the same way. So for example, one partner might get 60% of the profits but only 40% of the losses. And you'd say, why would we do that? Well, that can be an advantage when the two partners have other income from other sources and somebody's in a higher tax bracket. They might want to take a higher percentage of the losses in order to help them in their other, because they have a higher tax rate. So some of the disadvantages of limited liability companies is that when they're trying to do business across state lines, it can sometimes get a little bit confusing because there's not as much uniformity as we would hope for in limited liability company laws across state lines. And another disadvantage is that because they're relatively new, now they're not that new, they've been out since the early 90s, but because they're relatively new, there's not a lot of case law and history on interpreting limited liability company statutes. Of course, that's improving every year as they go on, but that's one of the concerns we have with them. Management of an LLC is also flexible, so I would call that an advantage in that it can be managed by all the members, just like we would with a partnership, or we can say it's going to be managed by managers. Now, the managers could be a subset of the members, or it could be non-members, and so that's a really nice thing. I would call that an advantage of an LLC. Now, finally, we're going to go on to corporations. So corporations are they've been around for hundreds of years, and so they're well understood. They have people have heard a lot about them. Corporations have a lot of advantages, but they also have some disadvantages. So in a corporation, we have shareholders. The shareholders are the owners. We have a board of directors. The board of directors shares ultimate responsibility for managing the business, but generally the board of directors does not manage the day-to-day operations of the business. The day-to-day operations are managed by officers. So as you can see, compared to the other business entities we've gone over, there's a lot more structure or organization in a corporation, and that can be an advantage for a big business because they'll need that, but in small businesses it can be a little bit of a disadvantage because they really don't need that much structure or organization. One of the nice things in the state of Utah with corporations is that the statute allows us to fill all of those positions with the same person. So we can say, well, there's only one shareholder, so we only need one director, and we need one officer, and that can be all the same person. So that makes it nice, and I would call that an advantage with the way the Utah statute is written as far as corporations goes. So ultimately with a corporation, the shareholders control who runs it, and the way they do that is by electing a board of directors, and then the board of directors hires officers. So ultimately the owners have control, but it's a little bit more attenuated or difficult than, for example, a sole proprietorship and partnership. So it distances probably the owners a little bit more from the controlling who is running the business compared to other types of business organizations, and I would call that a disadvantage. Corporations generally, historically, had a huge disadvantage in that they were subject to double taxation, and that's the case if a corporation is set up as what's called a C corporation. Subchapter C is just a part of the Internal Revenue Code, but what that really means is the business pays taxes, and then after the business pays taxes, the corporation pays taxes, I should say. It distributes dividends to the owners, and then the owners pay taxes on those dividends. And so that's where we come up with the double taxation. The double is the business pays, and then whoever receives the dividend pays. So it's taxed twice. That's a disadvantage because it means the tax, if you do the math, they pay more taxes. So that's a huge disadvantage. So fortunately, we do have what's called the Subchapter S election, which corporations can make, and there are some restrictions on that based on the number of shareholders, the country of domicile of the shareholders, and the nature, whether they're trusts or whatnot. And so there are some restrictions on whether or not a corporation can qualify as a Subchapter S. But if a corporation can qualify as a Subchapter S, that can be a good thing because it allows the corporation to avoid the double taxation, and they're really taxed just like a partnership would be taxed. So instead of the corporation paying taxes, that tax liability is passed through to the shareholders, and they pay the taxes on the corporation. You might guess, well, there's a disadvantage of that, and the disadvantage being that the corporation might not give any dividends to shareholders, and they might be forced to pay taxes, and that is a big disadvantage. And so most of the time with Subchapter S corporations, we write a clause in the bylaws saying that they have to give the shareholders at least enough money to pay their taxes, and depending on the business needs or circumstances, sometimes we'll say they even need to give more than that. But regardless, that's a big concern, and that's something that needs to be addressed in the bylaws of the corporation. So let's see, other advantages, disadvantages. Just like a limited liability company, corporations have limited liability. They don't have it in their name, but they do have it, and so that's a big advantage of corporations. The shareholders are not liable for the torts or business debts, contractual debts of the corporation. The extent of their risk is whatever they invested into the corporation at the beginning. And so if the corporation were to have a huge lawsuit against it and go belly up, the shareholders could not be forced to pay more money to satisfy those debts. So that's a huge advantage of corporations. There are some other, when we talk about tax advantages, there's some very subtle advantages of corporations if people are trying to do 401ks or those types of things. I won't go into that here because that's rather involved and it doesn't apply to very many people. But if you're interested in doing something like that, you may want to talk to an accountant or an attorney about that to get more detail. So finally, one of the major disadvantages of a corporation is the paperwork. Of all the business entities I've talked about, corporation has the most paperwork. Just like a limited liability company, a paper has to be filed with the state when it's set up, and then each year. So those are the limited liability company and corporation are the same as far as that goes. But the difference is, unlike limited liability companies, corporations have to have an annual meeting of shareholders. They have to have at least an annual meeting of board of directors, and minutes need to be maintained for these meetings. And so in the end, what happens is a corporation ends up being more paperwork and more headache than a limited liability company. And so generally one of the questions we ask clients when they're deciding whether they should set up a limited liability company or as a corporation is, are you the type of person that can do paperwork once a year and remember to actually do it? And if they say yes, then a corporation might be good for them. If they say no, then we'll offer a service of doing that paperwork for them every year. But it does, obviously, there's a fee involved in that. But if they say no, they don't want to do that, then a limited liability company is a better choice for them. The problem with not doing the paperwork in corporations and keeping that up every year is that if a corporation fails to do that, that it can lose its limited liability protection. And so that's really one of the major advantages of setting up a corporation in the first place. And now that goes away. So that's a huge problem. So those are the types of business entities in this. Well, sorry, I forgot one, didn't I? Limited partnerships. Limited partnerships were a hybrid between corporations and partnerships, and they were really popular because they had some of the advantages of both. In all honesty, we don't recommend limited partnerships very often now that they've come out with a limited liability company, because a limited liability company, in our opinion, really has the advantages of the limited partnership without the disadvantages. One of the huge disadvantages of the limited partnership is that at least one of the partners has to be a general partner, so that general partner is liable for all debts of the partnership. Now, the way that's addressed is to set up another entity that will become the general partner. So now you set up an entity that has limited liability protection to become the general partner, but that obviously begs the question, why are we setting up two business entities when we really only need one? So that's why we generally steer clients away from the limited partnership, but they do still exist in the state of Utah as a viable business entity. So there you go. That's the type of business entities that we have in the state of Utah. If you have any more questions, please feel free to email us or give us a call at the number that appears at the top of our webpage. And thank you.